May it please the court, my name is Ben Phipps. This is Don Banks from the Bay County Attorney's Office here today with me. Together we're representing the appellate in this case, the Bay County Value Adjustment Board. This case is one of statutory construction. The statute is section 194.035. That is one of the statutes that's contained in part 1 of chapter 194, a chapter dealing with administrative and judicial review of property challenges, property tax challenges. Part 1 is the Value Adjustment Board process. Part 2 is the judicial process.
Counsel, is there any kind of procedure in place or mechanism in place that allows a taxpayer to challenge the recommendation of the special magistrate? I mean, can a taxpayer file exceptions to the magistrate's recommendations, for example?
A special magistrate's determination is simply a recommendation to the Value Adjustment Board, Judge Clark. Under the rules and under the statutes, that's a preliminary step that must be completed by the Value Adjustment Board itself.
But the question I'm asking is, and often when magistrates are used in other circumstances, in probate or dissolution cases, the parties can file exceptions to the special magistrate's report. For example, I'll be able to challenge it by saying the magistrate just got it wrong, maybe even had the wrong property, maybe didn't consider certain things. Is there some kind of way for a taxpayer?
Judge, that's exactly what happened in this case. And the Value Adjustment Board of Bay County and many other counties, Broward counties particularly, as the record reflects, set up a procedure for the taxpayer or the property appraiser to bring a challenge before the Value Adjustment Board, challenging the determination of the special magistrate. And that's the issue that's before the court today.
Mr. Phipps, that's something before we get into the argument on interpretation of statute. I'm a little concerned to understand procedurally what you view happened in this case, because as I understand it, a block of hearings were held before special masters.
That's correct, sir.
And they submitted their findings to the
That's
Value
correct.
Adjustment Board. The Value Adjustment Board met and accepted the findings of the special master.
That issue was never addressed nor resolved by the trial court. What happened was that the appellee...
See where I'm going with this?
I understand exactly where you're going.
Was the April hearing a second hearing after they had already had one hearing and accepted the findings?
As I say, sir, what happened was that when the...
in other words, how many bites of the apple would you get?
What happened was when the property appraiser went before the trial court, he asked for a summary judgment on the basis that regardless of the procedure that had been followed by the Value Adjustment Board, that under no circumstances, regardless of what they had done, that a Value Adjustment Board, as a result of the 2002 amendment, does not have the authority to conduct further hearings. So it doesn't matter what happened at the March 17th hearing. We feel that what should actually happen in this case is that this court should reverse that determination of the judge that in her interpretation of the 2002 amendment, that the boards lost under all circumstances the right to actually hear a contest with the special master.
Well, let's assume that they had the right to conduct a hearing.
Yes.
And there's some indication from the statute that they could have a hearing even though a hearing had been held by a special master.
Yes.
They convened in March and accepted the findings of the special master, did they not?
Actually, once again, that matter has never been resolved by the trial court.
Yeah, that's
now what actually happened, excuse me, I'm sorry, sir.
Are you simply suggesting maybe all they did was get there and they filed the special master's report?
What happened was the special magistrate's reports were submitted to the board. The board says we will adopt the special magistrate's report subject to an appeal.
Don't the minutes say they accepted the reports?
They accepted the report subject to an appeal.
Subject to an appeal?
Yes, to an appeal to the board.
You mean subject to a right for a hearing before the Value Adjustment Board?
That's correct, sir.
I would suggest they didn't adopt the findings.
They adopted the findings, both the motion and the notification that went out to the taxpayers said that the board has adopted the special magistrate's recommendations subject to you, either the property appraiser or the
different
special.
words. Did they accept it? Did they adopt it? Did they consider it? Because the statute requires that that the board consider the recommendations. But I'm hearing different words that you're using.
They said what the board did was they moved to accept this recommendations of the special magistrate subject to an appeal. Now, if the reason they did that, I believe, is because there were 669 cases in which the special magistrates ruled for the taxpayers. And all cases that were not going to be appealed, that would conclude the proceeding. If there was an appeal filed, then they actually set down the date of April the 24th to hear those appeals. And that was provided for under the rules of the Value Adjustment Board that had been in effect for several years.
Mr. Spitzer, here's another thing that concerns me in use of terms. If there is an appeal would connote that you have a record and you have to challenge it either on an error of law, abuse of discretion, or the absence of evidence to support the fact finder's ruling, not that you can present new and different evidence.
I totally agree, sir, and I don't think that new and different evidence was submitted in any of these cases that I'm aware of. There's a subsidiary issue in which there were some people who had never appeared before the special magistrate and who made their initial appearance before the board, but that's not the issue that's before this court. Once again, let's get...
If the Value Adjustment Board has the right to conduct a hearing in the context of receipt of evidence, that's one thing. And if that's what they did, then there may be a problem with the trial court ruling.
And we think there is, of course.
But if it's an appeal...
Well, the word appeal is used rather loosely. What the statute says is further hearings. Now, they can conduct further hearings in a strict appellate sense, or they conduct further hearings by hearing arguments on law, or they can conduct further hearings by taking, re-examining the evidence.
What did the board do at that further hearing? Did the board consider further legal argument, or did the board also consider testimony?
Judge Clark, there were cases in which there were simply legal issues involved, and they did hear further legal arguments on the conclusions of the law reached by the special magistrate. The bulk of the cases, however, were cases involving factual issues, and the evidence that had been presented to the special magistrate was essentially represented to the Value Adjustment Board. And
was there argument to the board that the special magistrate erred by making the following findings, and then set forth what the error was? Yes.
Please understand that Value Adjustment Board proceedings are extremely informal and are intended to be extremely informal. These are not 120 proceedings. The statute itself specifically provides the caveat that these are not 120 proceedings. These are as informal as you can possibly get.
Sure,
in fact, they're pretty conversational, They're not the least bit like what we're conducting here, and they're not intended to be. They're intended to be an opportunity for taxpayer citizens to come before their officials that are actually going to set the tax rate and contest the assessments on their property or the determinations that have been made by the property appraiser.
But they're formal to the extent that both at the board and before the special magistrate, there are rules of evidence to be complied with and rules of procedure.
There are no rules of evidence involved. I have to say that that it's about as informal as it can get. There are some limitations on hearsay. All testimony must be under oath. I think that it's kind of up to the special magistrate. It's up to the board as to how strict they want to be on the evidence. The only rules of evidence which are extant in Value Adjustment Board proceedings are those governed by the rules and by the statute relating to the exchange of evidence which must take place prior to the actual hearings themselves. And that's fairly strictly construed by the special magistrates and by the boards.
And is there examination and cross-examination of witnesses?
No. There's a discussion that takes place between the special magistrate and between the property appraiser and between the taxpayer. These are just tripartite discussions, people sitting around the table and discussing how the property should actually be assessed. It is not the least bit like a trial or like a formal proceeding. And I think that this court needs to understand that this is a citizen participation type of activity in which neither the property appraiser nor the taxpayer is required to submit to question and response. It's open discussions. If I may, can I turn to the statute and so that we can get back to the issue of statutory construction? Let's take a minute and look at it. The 2002 amendment was the one in which is at issue. And this is the amendment to the actual statute itself. As you can see, the vast majority of the amendment simply related to the qualifications, the educational requirements that are placed on special magistrates, which were somewhat expanded in 2002. But the key language is that first sentence. And you'll notice when we go to that first sentence that the only thing that happened was that the boards were mandated, that is, boards having in counties of more than 75,000, were mandated to appoint special magistrates. There is no mandate whatsoever stripping the boards of their right to conduct further hearings. In fact, the word may conduct further hearings is left intact in the statute. Clearly, the legislature knew about the distinction between shall and may because they used the word shall, mandating that the counties having populations of more than 75,000 had to appoint special magistrates, but they left intact the word may as it relates to whether or not the boards could conduct further hearings after the special magistrates had entered their recommendations. As I stated before, in Bay County and in many, many counties, Bay County had formal rules specifically authorizing and providing for further hearings to take place once the special magistrates had entered their recommended orders. I think
now each of these taxpayers get notice of the hearing before the special master.
I'm sorry, sir.
Each of the taxpayers get notice of the hearings before the
They do.
special masters.
They're given notice.
Basically, if they don't like the hearing they get the first time around, they simply get a second time before the value adjustment.
That's if the board wishes to do that. Now, that's entirely within the discretion of a particular board, and we know from the Bath Club case, for example.
And in fact, the language of the statute says which recommendations the board may act upon without further hearing.
Yes.
So the board could just accept it.
In some counties, Dade County, there are just way too many cases to be heard for a board of 5 elected officials to sit out and hear those cases. And so they don't do so. Broward County, which is nearly as large a county, which has thousands of board proceedings, nevertheless chose to actually allow taxpayers and the property appraiser to appear before them if they chose to do so, if they sought a hearing before the actual board. Bay County did the same thing.
Well, if the board intended to conduct further hearings, what was the purpose in accepting the recommendations and finding of fact from the magistrates, if they were simply going to reconsider those findings and recommendations?
Because, as I said, there were. Let me give you the numbers. There were 1,597 petitions that were filed in Bay County in 2007. Of those, 757 actually went to a hearing. Of those, 669 were in favor of the property appraiser, primarily because the special magistrate determined that the taxpayers had failed to overcome the presumption of correctness. There were 88 in favor of taxpayers. Of those 88, ironically, the property appraiser asked for an appeal, a hearing, before the board. And of the 669 in favor of the property appraiser, only 28 asked to be heard before the board. Of those 28, only 17 rulings by the board were in favor of taxpayers. So we're really only talking about 17 cases here out of a total of almost 1,600 that were filed initially. Now back to your specific question. I'm not beating around the bush. I'm trying to give you the background. The board did not wish to have to meet again for the express purpose of adopting special magistrate's recommendations if an appeal had not been taken. So they tried to do that in that first meeting. He said, we adopt the special magistrate's recommendations subject to an appeal. No appeal was taken, then that would have constituted final action. In fact, on the advice of their counsel, they did have a second determination and did subsequently readopt the special magistrate's recommendations as their final orders, even in those cases that were not heard on appeal. I think one of the interesting things is we have to look at how the Department of Revenue views the situation. And the Department of Revenue, in their findings in this case, stated in finding number 4, the department understands and supports the board's efforts to provide citizens the opportunity to present their cases directly to the board members. The board understands and supports that. I think I'm down to enough time that I probably ought to reserve some time for rebuttal, if I may. Thank you.
Please, the court. My name is Larry Levy. I represent the property appraiser here today. Let me straighten out the facts first. There's no question about what happened on March the 13th. It was approved. They approved the recommendations. The trial court noted it. It said in the letter, you can find it. It's in the second tab in the appendix, I believe, appendix.
And it is the word that the board used, approved?
Approved. I'll read it to you. Please find attached a record of decision from the 2000. This is the letter that went to various petitioners. Mm-hmm. Please find attached a record of decision of the 2007 Value Adjustment Board. The VAB approved the recommendations of the special magistrate at their meeting held on March 13th. The trial court, in its order, we're on page, on paragraph, I believe it's the third paragraph. After the special master's hearings that had been completed, the VA met on March 13th and approved all of their recommendations. That's the trial judge doing it. He got undisputed facts.
All right, now let me ask you this then. The statute requires that the board appoint the special magistrates for purposes of taking testimony and making recommendations. Does this statute anywhere prohibit the board from taking further action? In fact, doesn't the statute say which recommendations the board may act upon without further hearing?
Yes. The statute says exactly that.
Does it say that the board cannot consider anything further?
No, but there's none that authorizes them to hear appeals either, further.
Well, what if they had just called it further hearing rather than called it an appeal? Is it the label of what they called it is that dispositive in this case?
No, it's not the label. It's the circumstance, what actually takes place of these. Once you have a final hearing, you have a final hearing. When you meet and approve the recommendation of the special masters, that's done. And then they say in the letter, which you can see in the appendix, we are going to allow appeals.
And here's my question. Suppose that letter had not said we're going to allow appeals. Suppose that letter said to these taxpayers, we're going to have further hearing on this issue. Would that have been allowed pursuant to the specific wording of 194-0351?
That language does have the word, we can have further hearings in it, but it doesn't authorize an appeal. And
my question is, what if they hadn't called it an appeal?
You would have to have that if you're dealing with a public officer. They can do which is specifically authorized. There's nothing authorizing them to hold an appeal.
But it seems to me that it is authorized that they have further hearing.
Yes. Further hearing.
And if they hadn't called it an appeal, they could have had further hearing.
They had already had the further hearing when they met and adopted the findings of the special masters.
Would it make a
difference? That's what they did. That's the only way you can do it.
Would it make a difference if they hadn't accepted?
I'm sorry?
Would it make a difference if they hadn't accepted and approved the findings of fact? Could they then hold further hearings?
If they had two hearings, you mean?
Correct. If they had not accepted the magistrate's finding of fact and recommendations and then allowed the petitioners to come in and appeal, or excuse me, to have further hearings.
Not
They
really.
do
You can't, they're dealing with an appellate procedure, but they're going to allow further testimony and evidence. That's clear.
Well, if they haven't made a final decision, the scenario here is where the board has not accepted the recommendations of the
I
magistrate.
couldn't hear you. I'm sorry.
Okay, the
I
board.
wear hearing aid and I don't hear well.
I'll scoot up. The board has not accepted the recommendations of the magistrate or the finding, and then notifies the citizens that they may have further hearings. Would that be proper in your view?
No, the further hearing part would normally be, we have received, we have not acted on them, and we can set a time, let you come in here and ask for a review. Their rules provide if you want a review, but generally, you don't get two evidentiary hearings because of the change in the statute in 02. It says
You're saying
special
generally, but
masters
I'm
must be
looking
used
for you
for
to point
that.
to some words to say that.
Beg pardon?
You're saying generally what happens. What I'm looking for you to do is point to some words in the statute that divests the board of having, of being able to have further hearing.
I think there is. I don't think it, well, I don't, the way that I would read the statutes and the way the trial judge read them, and the general rule says that when you read a statute to find out what a public official is authorized to do, you read to say, and he is authorized to do so and so and so and so.
Sure.
Here you say, this is a permissive thing. You can act on this without holding another hearing. That's recognized as a Bath Club case that was cited in one of the briefs, and it talks about a situation where somebody was complaining. Well, the special masters, once they get their ruling up to the VAB, they just kind of adopt them and don't do anything, and that violates due process. Said no, you had your hearing before your special master. That changed in 1972. Any county with 75,000 over, and Bay is one, must use special masters.
Sure.
They can't come in later and say, well, I didn't like what the special master said, so I'm going to go there and ask the VAB, and I may get a better deal. That way you've got two bites at the apple. You get the one. Every one of these people, except some never went to the special masters at all, went to the special masters, either had something, either got something, or did not get it, but they had their hearing. You don't get 2 days in court.
Well, Mr. Levy, Mr. Phipps tells us that that's just what appeal means, that it's a term loosely used in the statute, and what it means is that once you've been before the special master and the report is submitted to the board, you're entitled to ask the board appeal for another hearing before them.
That's what Mr. Phipps says. And we don't.
You're saying an appeal means appeal.
We're saying that once they have met and finished their work and approved the special master's reports, they can't say, come back and appeal to us and we'll give you something else. Now, that's what happened here. Everybody that went up before the board the second time, except one didn't show up. They got reductions. So typically what would happen, you would ask the taxpayer, well, what do you think your property's worth? Well, I think it's about worth so-and-so, what it was last year, so they cut it in half. That's what went on. There wasn't any. But they also make it very clear, and the trial judge found that these were second testamentary, evidentiary producing hearings, and they've already had one. The special masters have already been heard, and the statute changed in 02 says every county over 75,000 must use special masters. The reason? Because we want to get special expertise involved in the decisions. That's what you want in there. And you get it away from possibly local political favors, one side or the other, either for the property. The concept of I'll say perception was that the county commissioners will help a property appraiser. Well, they can also help the taxpayer for political reasons.
Now, this scheme doesn't contemplate that the special master is going to render the final decision. It's still the board that renders the final decision, right? And I say that because Rule 12D, 10.002, which governs these proceedings, says that the special magistrates appointed by the board act in place instead of the board, except to render final decisions. So it's still the board that's responsible for rendering the final decision, correct? Rather than the magistrate.
It would ultimately be, after the special master has done what they're going to do, they have to prepare findings of fact, conclusions of law, and send them to the special master. Send them to the board.
Sure.
The VAB then takes those, looks at them. In this case, they approved them. But then they decided, well, we're going to also hold appeals from our own decision, approving them, and let them decide, do you don't like that approval?
All right, let me ask you the
Get
same
some
question I
more
asked
relief.
Mr. Phipps. what if the board, in sending out their letter, had not used the word appeal? What if the board had said, we're going to conduct further hearing, so you can come back in for your further hearing? Would
They
that
could
be
not have
approved by
conducted,
statute?
they could not have conducted the hearings like they did here. And they would have had to do that before they approved them.
And
You
what in
can't
the
wait till
statute
after the
says
ball
that?
game's over and come in and say they would have had to do it before they could have received them, and says, this is you, everybody has received them. Is there anything you don't like about them? We're going to be looking at them, and we'll make a decision on approving them or not. If you have any problem with it, you need to write us a little notice or something yet.
Now, I understand the procedure that you just described, but I don't see where that is in the statute. I don't see where that is in 194-0351.
Well, it's in there because there's no authority to do something else.
Except,
If you read a sheriff's duties, he has the authority to make arrests. He doesn't have the authority to regulate telephone rates.
right, but except this statute says specifically that the board may
That's right.
act upon the recommendations without further hearing,
Been there
which
all the
means it
time.
may act on it with further hearings.
Let me pose this hypothetical back. Suppose there were no special masters involved here. The board met. It heard evidence. It heard all the testimony you wanted to hear, and they came up with their decisions. And then they said, now we've got a decision. Now we're going to send a letter to everybody that this is our decision. We notify you. But we're going to send you another letter and say you can appeal our decision right back to us. Is there any statutory authority any place in 194 that allows a board to hold two hearings?
That scenario is not
And the
governed
answer
by
is
this
no.
first sentence of 194-035, because it starts with, the board shall appoint special magistrate, and then it goes on to talk about what they're to do with those recommendations. So that scenario doesn't even seem to be covered by 194-0351.
The only thing that changed in 02 is that the law was changed to say we're not going to let the board be the one hearing the testimony and taking the evidence. It's going to have to be a special master if you're in a county 75,000 and over. So the 75,000 county, their special masters do exactly what the board would have done if that statute had not been passed. And once they do it, the taxpayer is entitled to one hearing,
But
not
then
two.
the board
This gave them
has
two.
the responsibility to, and I quote, render final decision.
I understand what you said, but what's the question?
That it was just further discussion.
You have a set of statutes that have been set up, play like the 75,000 was never enacted in 02. How many hearings, how many VAB hearings is a petitioner entitled to? One. He can ask for one petition. He can go and be heard. He can put on his evidence and testimony, and a decision is made. And then if he doesn't like that decision, he has to go to circuit court. He can't come back and say, I want another trial. And when the only thing changed in the law in 02 was that the 75,000 threshold meant that many counties must use special masters in that fact-finding evidentiary procedure.
I mean, it almost seems that you're asking us to ignore the last several words of that sentence.
No, I'm not. No, I think it has the several words have a place to be used, but they don't have a place where you can have two evidentiary hearings, and that's what was done here.
Okay.
I've tried to couch that pretty clear in the briefs I did. You had one evidentiary hearing, and there's no authority for the VAB to hold an appeal of a decision of the special masters after they have already accepted and approved the appeal.
Mr. Lee,
Yes, sir.
when the statute says that the board shall remain in session until all petitions, complaints, appeals, and disputes are heard, what are they referring to on appeals?
They're referring to the appeals. It's an old archaic language that's always been there, where a petitioner is appealing, calls himself appealing the assessment placed on there by the property appraiser. That's language that's been in the statutes always, and their session that doesn't create any new authority to hold an appeal of their own decision. It's just a reference to any petition can petition to the VAB, or if he goes first to the property appraiser and he has a conference with the property appraiser, and doesn't get what he thinks he wants, then he files a petition, and in effect, he's sort of appealing the decision of the property appraiser to the VAB when he asks for a VAB administrative hearing. But it's just language in the statute. But there's no specific authority to have two tiers of administrative fact-finding hearing. None, never has been.
But that appeal would simply be to contest the basis upon which the appraiser ruled initially, not to conduct an evidentiary hearing?
Yes, sir. It'd be essentially what the petition does to the VAB. He says, we think the appraiser was too high. We want a reduction in value. And if he does that, if you're in a county less than 75,000, you go right to the board. You don't go to special masters. If you're in a county over 75, you cannot go to the board. You must use a special master. The effect of what is being argued here today is that none of that law ever changed with requiring the use of special masters, because it allows you to jump right over.
That appeal does not refer to appeal from the recommendations of the special master.
No, sir. There's even a Florida Supreme Court case. It's fairly old, but it dealt with some language where it talks about that a property appraiser may appeal a decision, but it says what is really meant is that's a de novo proceeding appeal. Williams v. Law, I think, is the name of it. It's not in any of the briefs. You get one bite at the apple, not two. And if you can think in terms of play like the 75,000 had never gone in, that statute had never gone in. How many times can you appeal to the VAB and present your evidence of testimony? Once. Now, the special master statute went in requiring use of that 75,000. If you're over that population threshold, when that went in, then you're going to have to use special masters. The VAB must use them. It can't involve itself in that process, and the reason for it, there are a lot of good reasons. People did not feel like you're getting qualified expertise out of 3 county commissioners and 2 school board members, and they want to fit into someone that has special expertise to hear our decisions.
Yes, he makes the recommendations.
And point out one thing. In this case, although that is in the statute, everybody had to use special masters. I believe, I'd count them again, I think there were 23 petitioners who had never gone to the special masters, have been heard. They just decided, well, since the VAB has opened it up again, we're going to go straight there now. So you had 696 parcels, but you only had 53 petitions. And I think 23, I think it was, of those had never even been to special masters. That's a violation of the law right there. If they heard them, and they heard the others too. I think I made this as clear as I can, and Kevin, maybe I muddied it up a little bit, but I tried to make it clear. You have a system that's been in place a long time, and the system generally works pretty doggone good for government work. If you get something that works 85, 90% of the time, everybody's ain't happy, but everybody gets due process. One fact evidentiary hearing, and then go to court if you don't like that. That's in the statute. So nobody loses their due process rights through the mechanism. They have 60 days. Even in this mechanism, if the trial court, if Judge Costello is upheld, the next step would be to file suit, and they got 60 days to do it. So there's nobody loses any due process rights. One trial, not 2. And if the 75,000 threshold statute had never passed, you would still get 1. If that had happened here, would they have been to come right back and say, well, but we did hear it, and we heard it ourselves, and we had evidence of testimony, but we're going to do a further hearing. You didn't like our first result, come back, we'll give you something better. That's why you get 1. I'll answer any other questions you have.
Thank you.
I agree with Mr. Levy that had the legislature said you get 1 hearing, and that when we pass that law, we're taking away from you the right to further hearings, I would agree with him if that's what the legislature had said. And that's the argument that he made to you. He argued that in 2002, the legislature took away from the boards the right to conduct hearings period. That's the main thrust of his brief, and that's the determination that he was able to convince the trial court to come up with in this case. When the legislature deprives somebody of their due process, even though it may be just a little bit of due process, they're going to do so explicitly and expressly. And they did not do so in this case. If you examine the staff report, it's absolutely clear that it was never the intent of the legislature that this act was designed to take away from the boards in the counties of 75,000 or more the right to conduct further hearings within their discretion if they chose to do so. That statute's as clear as it can be that that was the case. In our brief, we stated that this statute, this amendment, was simply a recognition of the status quo in that almost all counties were already using special magistrates who were making recommendations on which the boards could act with or without further hearings. The staff report states that the DOR reports that most counties are currently using special magistrates. This did not change the due process rights of taxpayers or the property appraiser appearing before the board. It simply stated that in the bigger counties, the medium-sized counties, we are now going to require all of them, even those that are not currently using them, to go ahead and use special magistrates. But,
well, Mr. Fitz, if that is the case, then it would suggest to me that the legislature has written a statute that says the Value Adjustment Board may deprive the citizen of that due process right, because it may choose not to give them a hearing. If they originally had a right to a hearing before the Value Adjustment Board, now they may accept special masters
without conducting further.
Giving them a hearing.
You're absolutely right, sir. You're absolutely right, and that's exactly what happened in Bath Club.
If it's the deprivation of a due process right, what difference does it make if the legislature took it away or the Value Adjustment?
And all I can say to you, sir, is a little extra due process is hardly a bad thing. And that's what we have here, is we have a Value Adjustment Board that wanted to give a little extra break to the taxpayers and to the property appraiser. Isn't it ironic that the property appraiser who actually appealed and asked to be heard by the board, despite the fact that the special master's recommendations had been adopted, is now saying that neither the taxpayer nor the property appraiser is entitled to an extra hearing? In those counties that choose to do so, who choose to grant a little bit of extra due process, under the statute that currently exists, they can do that. If the legislature wishes to withdraw that right, they can do so. But they have to do so explicitly and expressly, and they haven't done so. Now, all we're asking is that you reverse the decision of the trial court on this point. And it should then be remanded, and then the trial court can address the issue of whether or not the board, in fact, deprived themselves of jurisdiction when they took that step of adopting and approving the special master's recommendations, and take the other actions that are actually raised in the complaint and in the Department of Revenue's findings. But what is before you today is the decision of the trial judge that will deprive not just Bay County, but of all counties of their Value Adjustment Board's rights to grant additional due process to their taxpayers and their property appraisers if they choose to do so. Thank you.
Thank you. That concludes our cases today. Before we recess, gentlemen, I want to tell you I've really enjoyed your argument, and it's my last. I think I met both of you almost 40 years ago when I tried the first Santa Rosa Island tax suit. And I can't believe I ended up my career here in another tax case.
Well, which case was that? The Amelia Island case? Was that the Amelia Island case, did you say?
No, Santa Rosa Island, that's Strong versus Camp, where they tax the leasehold states over there. But, gentlemen, we're going to be in recess, and this is my last. Thank you.
We hope you come back as a